28. Anyone having business before the King's Justice and the Superior Court of Justice, attend now and you shall be heard. Long live the King, the Honorable Justice Hennessy presiding. You may be seated.
Good morning, all.
Good morning.
Good morning, Ms. Jones. I'm Gwynneth Evans on behalf of Canada.
Good morning, Ms. Evans.
And I'm joined by my colleague, Mr. Fisk, who is joining us remotely from Toronto. He will be sharing screens for a few things I want to put up on the screen before you. I want to start with your slide 34, which is where you reproduce section 112 of the BNA Act. So I'm going to ask my colleague, Mr. Fisk, to put up that slide 34. You told us that one curious thing about this section is that there's no provision about that there is a provision about the charging of interest on the debt over 62.5 million, but there isn't any provision for repayment of the debt. Do you remember that testimony
Yes.
that you gave?
Yes.
So let's read section 112. Ontario and Quebec conjointly shall be liable to Canada for the amount, if any, by which the debt of the province of Canada exceeds at the Union $62,500,000 and shall be charged with interest at the rate of 5% per annum thereon. So it tells us here that Ontario and Quebec conjointly shall be liable to Canada. You're not suggesting that Ontario and Quebec are not responsible to Canada to repay the debt, are you?
Yes. Your objection?
She's asking for a legal.
Not yet. I don't think. This is English language understanding of what that word is and what the I don't take it as a legal interpretation yet. Go ahead.
Well, I'm following upon Ms. Jones's testimony that there isn't any provision for repayment of the debt. And I just want to confirm, are you suggesting that Ontario and Quebec are not responsible to repay the debt to Canada?
What I read in section 112 is that they will be charged with interest and that Ontario and Quebec conjointly shall be liable to Canada for the amount of the excess debt. But I don't, I haven't been able to see a provision in there for a repayment of the debt or the liquidation of that debt.
Well, you mentioned that it says they shall be charged with interest. Is there any indication here that they're actually required to pay that interest, or will they just be charged with it?
My understanding of the word shall be charged would indicate that they would be paying interest if one, unless the province goes into default, but that would not be the first, obviously the first implementation on that clause. To be charged with, I would expect, would imply some kind of a payment of the interest.
So there's an implied payment with respect to the interest. Is that what you're saying?
It's in the other sections of the British North America Act, it is to be deducted from the subsidy.
Is there also an implied provision that since they're conjointly liable to Canada for the excess debt, that there's a responsibility for them to pay that as well?
Well, again, the interest is to be charged. Quebec, Ontario and Quebec will be liable to Canada. There may be a bit of a difference there. Again, if you're parsing it in a legal context, perhaps you have a different context for reading it. But I read this as being that Ontario and Quebec conjointly will be liable to Canada, but it's the interest that's actually going to be charged against them.
Although we have seen that amounts representing excess debt were added to the accounts of the province of Ontario and Quebec, isn't that right?
At the end of the arbitration process.
So you told us that while you were discussing slide 34 in your evidence in chief, you told us that there were some types of imperial securities which formed part of investment portfolios at the time that were intended to be perpetual debt on which interest would be paid, and that they were quite popular for pension and investment or pension and annuity funds. Do you remember that testimony?
Yes.
So I did not see any mention of these securities in your report. Is this something new that came to your attention after you prepared your report?
I didn't describe that in my report. That's true. It's not new to me, but.
But in this case, you've
yeah.
not provided any evidence of these imperial securities, have you?
I didn't produce anything about the consuls.
Thank you. All right, I want to move to slide 52, although I don't think we need to bring that slide up. What I want to bring up is the document you refer to there, which is at tab 55 of your compendium of the demonstratives. It's an excerpt from the Joint Book of Documents, tab 2790, and I'll ask Mr. Fisk to put that on the screen. This is a document that is, maybe Mr. Fisk, you can go to the first page. It's a series of excerpts of letters and what have you that were compiled, I take it, and put into the sessional papers. We can see that there.
Right.
So the part that I'm most interested in is the very last page, where page 10 of the of your tab 55. And here we're looking at a memo prepared by William Sprague of the Dominion,
Yes.
dated June 3rd, 1869.
Yes.
And you describe this as Sprague's observations elucidating the information in the foregoing table. And these tables, Mr. Fisk, if you could scroll up the page to, there we go. These tables record sales of land and annuities, not just in the Robinson territories, but throughout Upper and Lower Canada, isn't that right?
That's correct.
Okay, so then on page 10, William Sprague makes a note after noting at the top of the page there, the annuities under the Robinson treaties. He begins the paragraph, you can see it in the middle of the screen. The cessions to the Crown, in consideration of which the within named annuities are paid, comprehend chiefly the old settled districts of Upper Canada, whereon the greater part of the lands have many years since either passed into patents or the lands have been sold. He continues on. But what's relevant for our case is the next paragraph. With regard to the lands on Lakes Huron and Superior, in consideration of cessions of which the new annuities are paid under the Robinson Treaty, they are chiefly valuable for minerals. As respects the general question of the annuities, it should be borne in mind that the Government of Canada entered into engagements with the Imperial Government under which it assumed and guaranteed the payments. The lands referred to in this memorandum, which remain unsold, are the property of the province of Ontario and are at the disposal of the government of that province, and the lands which have been sold or granted have been so sold or granted as public lands. So looking at that first, the paragraph that begins as respects the general question of the annuities. It should be borne in mind that the Government of Canada entered into engagements with the Imperial Government, under which it assumed and guaranteed the payments. And you told the court in your evidence in chief that it's not perfectly clear whether Sprague means, when he talks about the Government of Canada, whether he means the province of Canada or the new Dominion. Did I understand that correctly?
I think that's right. Yes, because it would be the government of the province of Canada that would have entered into an engagement with the Imperial government.
All right, thank you. Because you did go on in your testimony to suggest that he meant the Dominion government, because he didn't use the word province as he does in the next paragraph.
Right.
But do you now say that in fact he did mean the province of Canada where he speaks of Government of Canada?
Well, I think it's true that this phraseology, Government of Canada, is not very precise, that it would have been the government of the province of Canada that would have entered into a direct engagement with the Imperial government. The fact that he does use the words Government of Canada here in 1869, what I was drawing some attention to there is that there is a thread which I described in my testimony that carries forward from the imperial government through to the province of Canada, and then for the jurisdiction over Indians and lands reserved for the Indians in the new British North America Act and the Government of Canada. So that I think the phrase is a bit ambiguous in that way. One would have thought perhaps he would have referred to the province. Perhaps he means both. Perhaps he means both there.
You told us that he may be referring as far back as 1835, when the government of what was then Upper Canada at the time undertook to pay annuities out of territorial revenues. Do you remember that testimony?
Yes.
So that again would link it to this idea that it was the province of Canada that undertook this engagement with the imperial government, entered into an engagement with the imperial government under which it assumed and paid annuities.
Yes.
And we haven't seen any documents in this case that suggest that the Dominion in that period of time, this is written in 1869, am I right?
Yes.
So almost 2 years after Confederation. Is that right?
Yes.
Almost 2 years after the Dominion first comes into existence, right?
Mm-hmm.
We've not seen any documents that in that almost 2-year period that the Dominion entered into engagements with the imperial government under which it assumed and guaranteed payment of annuities, have we?
There is an engagement which may or may not be related for Canada's acquisition of Rupert's Land, into which the government of the Dominion.
I just want to stop you there
Yeah.
because we'll be coming to that, but
Okay.
that is after. Am I right though, in this letter here, Sprague is not talking about Rupert's Land, is he?
No.
And in fact, if there had been a written communication or an instrument of some sort or legislation by which the Dominion undertook or entered an engagement with the imperial government on responsibility for annuities, then you wouldn't have to speculate that he's referring back to 1835. Isn't that right?
One thing that might be missing from this discussion is any more contextual information about what happened in London regarding the drafting of clause 9124 of the British North America Act. We don't have documentation about that drafting, but that is another moment at which the imperial government and the entities that were going to create the new government of Canada might have been considered to enter into some conversation to that effect.
Right, I understand that we don't have records of what was discussed behind closed doors in London in shortly before July of 1867. But neither would have Sprague, isn't that right?
That's true. He might have had, in fact, he did have contact with people who had been in London.
So it's
Yeah.
unusual then that he would be talking about the Dominion entering into engagements with the imperial government. In fact, there's no written record of it. Wouldn't that be right?
I don't know whether I don't know whether he would need to have had a written record to make that kind of comment. It is true that we don't have a written record, but he was, of course, a senior official in the province of Canada. He's now a senior official in the Dominion of Canada. So he does have contact with, say, people at a ministerial level. Again, it's not something that we can document in that particular part of the transaction.
Whereas on the other hand, we do have documentation that establishes, as you said, in 1835, the then government of what was then Upper Canada did enter into engagements with the imperial government
Yes.
to assume.
That part is
And
clear
guarantee.
from the documentary record.
Thank you. So getting back to Rupert's Land then, you have told us that, and Mr. Fisk, you can stop sharing that document, thank you. You've told us that the Dominion was to assume responsibility for any claims of the Indians for compensation for lands in Rupert's Land, which was transferred from the Hudson's Bay Company to the Dominion in 1869. Do I have that right?
Yes,
And this was because, with the exception of a local assembly in what was to become Manitoba, there were no pre-existing local governments in Rupert's Land. Is that right?
that's correct.
And so the only government that could take on responsibility for compensating Indians for lands would be the Dominion. Isn't that right?
That's right.
Thank you.
Could you give me a moment, please, to catch up? Thank you.
I want to turn to what we've been calling the Section 142 arbitration, which was the 1870 arbitration. At slide 54, and I'll ask my colleague, Mr. Fisk, to bring up slide 54. This is of your demonstratives, Exhibit 91. You refer to in the second bullet point, a 28th of May, 1870 draft judgment or award on a proposed method of apportioning the responsibility for the excess debt. And this was followed on September 3rd, 1870 by what you call the final award. Is that right?
That's right.
So I understand this is an area of your evidence which you told the court you differ somewhat from Professor Messamore with respect to whether or not this May 28th, 1870 document was a draft or not. Is that right? Did you say you view this as a draft, I understand?
Yes, this is the 28th of May is characterized as a draft
It's characterized by who as a draft?
by the arbitrators themselves. The arbitrator for the Dominion of Canada makes that clear.
Well, we'll
Like-
be looking at that document. I'm going to ask my colleague, Mr. Fisk, to bring it up. And maybe then as we go through these questions, you can point out to me where he uses that word draft. So this was at tab 58 of your compendium. It's an excerpt from Joint Book of Documents, tab 2813.
And what slide were we at? 54?
54 was the slide where it was mentioned.
Thank you.
And so the document we're looking at, this is again, I'm going to ask Mr. Fisk to go to the beginning of this document that was an excerpt from Joint Book of Documents, tab 2813. This is a series of again, from the sessional papers, a series of correspondence and meeting minutes from the arbitrators from the 1870 arbitration. Is that right?
That's right.
So if we look at the 19th meeting of the arbitrators, which begins on page 5 of 25 here of the electronic copy.
Oh,
It's the 19th, there we go. Thank you, Mr. Fisk. It's the 19th meeting of arbitrators. I remember we discussed this earlier because there was a note made that it was actually on a Saturday that the arbitrators met on the 28th day of May, 1870. And to recap, we've heard the evidence about this. I think it's fair to say that on May 28th, a decision was made of 2 of the 3 arbitrators, of arbitrator Gray, who had been appointed by the Dominion, and arbitrator McPherson, who'd been appointed by Ontario. But arbitrator Day, who had been appointed by Quebec, dissented. Is that right?
That's right.
Okay. So this May 28, 1870 decision of Gray and McPherson alone was the one that proposed what I'll call the local benefit principle for the division of debts. Would you agree with that?
In this award, it appears actually that they first refer to the assets in the 4th schedule and ascertain the origin of the debt which was required to create those assets in the fourth schedule, and then to divide debt that was where no asset was left behind.
And then they go on to say, and then we'll use this local benefit principle, carry on in other contexts too. Is that right? We can get to it if you're.
Right.
We'll wait and get to it then. But just to differentiate this May 28th, 1870 award from what you call the final September 3rd, 1870 award, is it fair to say that the May 28th award discusses principles to be applied in the division of the excess debt, whereas the final award in September actually provides the numbers, which work out to roughly 53%, 47%. Is that right?
Yes, the final award sets the proportion.
Right. So this document will, I call it a judgment. I understand that you call it a draft. But this May document indicates then just a proposal for how the distribution should be calculated, but the final in September actually does the distribution by providing the numbers. Is that right?
Yes.
All right. So let's take a look at I'll have Mr. Fisk scroll down then again to page 5, or scroll up, I guess, to the 19th meeting of the arbitrators, where they're meeting on the 28th of May. And you can see there's a discussion about arbitrator Day submits a proposal, and then arbitrator McPherson submits a proposal. And I guess I want to look at principle 3, which I think is on page 7 of the document. Here we go. Did I get that right? Oh, here we go. Judgment. All right. I want to look at this. Now, Gray and McPherson render what they call a judgment. Would you agree with me there that the title is there, it says judgment? They called what they rendered a judgment. Is that right?
Yes.
And they say that the arbitrators under the British North America Act, do you see where I'm reading from?
Yes.
I don't, so.
It's under the heading judgment
On,
on the
Got it.
7th page of,
can I call it page 23
yeah,
of the
that would be
document?
fine. You don't need to highlight it. It's all right, Mr. Fisk. I think I'll just read it. Yeah, is it possible, Mr. Fisk, to increase the size of this? Thank you very much for trying.
It also appears to be on electronic page 714 of 1,009.
Thank you.
Thank you.
All right, so under the heading judgment, it says the arbitrators under the British North America Act 1867, having carefully considered the statements made and the propositions submitted respectively by and on the behalf of the provinces of Ontario and Quebec, and having heard counsel at length thereupon, do award and adjudge as follows. So, and here then we have in the third paragraph, the paragraph number 3, this local benefit principle. They award and adjudge that the division and adjustment between Ontario and Quebec of the surplus debt, that beyond 62.5 million, et cetera, shall be based upon the origin of the several items of the debts incurred by the creation of the assets mentioned in the 4th schedule to the Act, which is what you mentioned to us. Is that right, Ms. Jones? That's
Yes.
what you're referring to. And shall be apportioned and borne separately by Ontario and Quebec, as the same may be adjudged to have been originated for the local benefit of either. And where the debt has been incurred in the creation of an asset for the common benefit of both provinces, and shall be so adjudged, such debt shall be divided and borne equally by both. This is what certainly Professor Messamore referred to as the local benefit principle. So Justice Day from Quebec, appointed by Quebec, dissents from this. Isn't that right?
Yes.
And if we take a look at page 8 then, which was page 24 of the sessional papers there, under we see first of all the signatures, or it's indicated they had signed, arbitrator Gray, arbitrator McPherson, but Judge Day has dissented. And then we see that arbitrator Day would appear quite upset by this decision of just 2 of the 3 arbitrators, because he requested that the decision arrived at should not be communicated to council until he could speak about it. Is that right?
That's right.
So he was concerned about having that judgment of only 2 of the 3 arbitrators communicated to the parties or formally announced. Is that right?
Yes.
And arbitrator Gray then, who had been appointed from the Dominion, attempted to facilitate an agreement among the arbitrators. Is that right?
Yes, he did.
So after we see the dissent, then we see arbitrator Day's dissent is written in this document, but then I want to scroll to a little bit further down, page 8. Or sorry, I guess now we're going to go to page 12, because now after hearing Justice Day's dissent, there's a few other meetings of the arbitrators, but at page 12 again, we see, and actually
Page
this-
12, so I'm going back in the document.
sorry, no, I'm going to use the numbers on the document itself. Mr. Fisk, can you just show me at the bottom of page 11? Thank you. So, Your Honor, we're starting at page 27 of the actual
Got it.
document.
Thank you.
So, all right, so we have arbitrator Gray has tried to facilitate an agreement. You mentioned that in your evidence in chief. Now, ultimately, arbitrator Gray says, and this begins on page 28. Thank you, Mr. Fisk, just a little bit lower down. Oh, here we go. This is good. This is arbitrator Gray, appointed by the Dominion, who's communicating his efforts to strike some kind of agreement among the arbitrators, because arbitrator Day is upset about this idea that there's a judgment that's only been rendered by 2 of the 3 arbitrators. And arbitrator Gray for the Dominion is saying that the point, so arbitrator Day is saying, I don't want this formally announced. And arbitrator Gray for the Dominion is saying, I'm going to have to formally announce this. This is a judgment, like it or not, that you don't agree with it, is ultimately what he ends up saying. I'll put that to you. He says, in the ordinary mode, if this was a private matter, this is in the middle of the page. If this was a private matter, there would be no difficulty about it. Parties having agreed to a reference and having requested a decision, whether interlocutory or final, must take it, unless by consent it is abandoned. The point now to be considered is whether in an important public matter, such as this arbitration between Ontario and Quebec, sufficient grounds exist for a departure from the ordinary mode. I have exhausted every effort to bring about an agreement on this point between my 2 colleagues, and have delayed giving any opinion until compelled by the necessity of the arbitration being either abandoned or proceeded with. A week has elapsed in unavailing efforts to do so, and I am most reluctantly compelled to decide. This is where he says, I have to observe that the decision of 28th May last is not final. It is not like an award of the arbitrators on the division and adjustment. It is only an opinion of the majority of them as to the best mode to proceed in the division. If in working it out, it is found to operate unfairly, it is open to be reviewed and rescinded, and such other mode adopted as may be shown to lead to a fairer result. So he goes on to say,
Are you putting any
Question.
propositions to the witness?
well, I want to ask where you see the word draft. What makes you believe this is a draft? And this is one passage you had referred to in your evidence, where arbitrator Gray says, it's not like an award, it's not final, it's not like an award of the arbitrators on the division and adjustment. Do you interpret this to mean that this is just a draft?
I interpreted the words not final and open to be reviewed and rescinded as indicating that it is not a final award. It is a proposal as a method of proceeding It is not in that way the award that they have been asked to make under section 142. The methodology in the award can be changed. If in the working out of it, it turns out not to be fair or workable. So in that respect, I have called it a draft.
Would you agree that it's a guide for how the division should ultimately be done? Would you agree that it's a guide for that?
Yes.
Thank you, because Professor Messamore described it as a guide. And in fact, Arbitrator Gray describes it as a guide as well. And I think if we scroll down at the very end of page 28, it says, it is not, carry on to page 29, it is not conclusive. It is a mere mode of inquiry and open to correction. The decision made by us is no iron rule, but simply in the light of a guide to be construed liberally. And he goes on to say, so in fact, what he's saying is, this is a guide as to how the division should occur. These two arbitrators, Gray and McPherson, are saying it should occur on the basis of the local benefit principle. The local benefit principle should be a guide, is what he's saying. Is that right?
Yes, although McPherson has actually, before that award was issued, he indicated his strong preference for using population as a mode of division.
But ultimately, though, population doesn't factor into this May 28th.
Yes.
That's because I don't.
Okay, thank you. Ms. Jones, if there's ever a point where you think you like to finish a sentence, just indicate that, okay? And Ms. Evans, you were about to say.
I'm not interested in going, we have heard already testimony about McPherson's original ideas, but what I'm talking about here is this May 28th document, which you've characterized as a draft. And I think you've now agreed that it's in fact a guide for how the arbitrators should ultimately make their decision on the distribution of excess debt. Is that fair?
It's been put forward as a methodology to be tried. It is not, according to the arbitrator here, to be considered the final methodology.
Thank you. And so we see that at the end of Arbitrator Gray, at the end of his speech, where he says that it's meant to be in the light of a guide for how the division should be made, he therefore concludes, however, that at the very end, I agree, therefore, with Mr. McPherson that the decision arrived at on the 28th of May last should be formally announced to the council and provinces concerned. So this is actually issued as a judgment. It's not just a draft, it's an issued judgment. Would you agree with me?
Well, it is going to be formally announced. Whether at this point it is to be considered the final methodology or the final working out, that I'm not sure that that's implied there. What I see is that it should be formally announced to council and the provinces concerned. So perhaps there is a legal implication of that, of which I'm not aware.
So obviously Arbitrator Day felt that there was a significant implication because it was on this basis that he resigned from the arbitration. Isn't that right?
Yes.
He resigned because of this judgment of only two of the arbitrators saying, here's a guide as to how we should distribute the excess debt. Isn't that right?
Yes, that's true. I think he felt that even by undertaking to work out how this would work on the basis in which Mr. Gray has described it, which is a proposed mode, that he might be seeing as concurring in a mode of division with which he and apparently his government that appointed him could not agree.
Thank you. Okay, I think, thank you, Mr. Fisk. You can stop sharing that document. I want to move on to the period after the 1892 arbitration. So this is after the decisions of the Supreme Court of Canada and the Judicial Committee of the Privy Council, that the Robinson annuities are to be considered a debt of the province of Canada, responsibility for them to be split between Ontario and Quebec. Have I summarized that fairly?
Well, the ruling of the Judicial Committee of the Privy Council, in my understanding, and the way council explained it at the time, was purely on the application of section 109. They did not actually opine on the joint liability question.
Thank you for that. Thank you. That's, I think you're correct there. That's a more accurate way to put it. But we're now in a position where after these decisions, the Dominion, Ontario, and Quebec are in negotiations to determine how much should be added to the debts of Ontario and Quebec in respect of three things: the annuity arrears for the years in which they were payable up to 1874. Do you agree with me there?
Yes,
The annuities up to $4 from 1875 to 1892 being the date of the arbitrator's mandate. Is that right?
yes,
And then the third thing being, eventually, the Dominion, Ontario, and Quebec say, let's also discuss a capitalization amount to fund annuities from 1892 into the future. Is that right?
yes,
So the three parties are discussing these three items that need to be resolved.
yes,
All right. So, and we have heard that during these negotiations, Canada took on certain responsibilities. For example, Canada had already been paying the Superior First Nations $4 per person since 1874, and it committed to continue doing so, even knowing that Ontario's numbers were showing no net revenues from those territories. Is that right?
Canada and Ontario's numbers, the accountants had been working jointly on these statements, yes.
So when you say Canada's numbers, were any of the revenues actually from Canada? From the Dominion, I should say?
There were mostly on the expenditure lines, but for example, Canada had been able to produce some revenue numbers that it had carried over from the province of Canada prior to Confederation.
So Canada, the Dominion, that is, had that information in its records, but of
Yes.
course, since it hadn't even come into existence until 1867, they weren't actually revenues of the Dominion prior to 1867, isn't that right?
They were revenues of the province of Canada.
Okay, thank you. So even knowing Canada, the Dominion, even knowing that it would not be able, Ontario and Quebec would not agree to fund any annuities up to $4 per person after 1874, the Dominion was nevertheless paying those annuities to the superior annuitants, isn't that right?
Yes,
All right. And you also told us that not only was Canada paying the superior annuitants, knowing that it was not going to be able to recoup any of that from Ontario and Quebec, but Canada was also paying more annuitants. Well, I think this is too many layers to this question, so let me back up a bit. Let's talk about the capitalization. So you told us that when Canada was negotiating with Ontario and Quebec, it had proposed, we obviously need a number, a population number to use in the calculation of the capitalization amount required, because you need the number of annuitants times $4. Is that right?
yes.
And so Canada at the time was actually paying, you told us, about 5,300 annuitants, 5,300 annuitants in both,
That's an approximation, yeah.
in both the Robinson and Superior territories combined.
Yes,
And Canada ultimately agreed, for the purposes of the capitalization, to use a figure of 2,650.
yes,
And I think we heard from you that Canada had started out with 2,800. Well, they started out with a higher number. Let's look at only the Hurons. Let's reduce that by 20%. Let's cut it down further to make Ontario and Quebec happy. Is that fair?
what Ontario and Quebec can be asked to pay, I think, was the language that the accountant of the Department of Indian Affairs used. And then Canada's council suggested to them that Ontario and Quebec might only be willing to pay $26.50.
And this is because certainly we knew Ontario's position was that Canada's pay list was too generous. It included many people that Ontario did not think really should qualify as annuitants. Is that right?
That's correct.
Okay. So Canada accepted in these negotiations, accepted a capitalization amount that was based on a number far below what it was actually, a number of annuitants, that is, far below the number of annuitants it was actually paying. Is that right?
Yes.
So we see in a couple of instances now where Canada has appeared to take on responsibility for annuity increases, knowing that it won't be able to recoup that from Ontario and Quebec because Ontario and Quebec won't agree. Isn't that right?
That's right.
So would you say that, I think you told us one of the documents indicated that Canada was really motivated to settle. Is that right?
They were motivated to settle. And I think that, as I explained in my testimony, Canada felt that it was vulnerable on the number of people that might be said to be legally entitled to annuities in the context of the 1890s.
Just can I stop there?
Yeah.
Vulnerable vis-a-vis who? Vulnerable to who?
Vulnerable to Ontario's conviction, really, that Canada might have been paying as many as twice as many annuitants as in Ontario's view of the legislation at the time would actually legally qualify for annuities.
So if I certainly understand why Ontario would want to keep the numbers low. They'd take the position the numbers should be lower if they're being asked to capitalize that amount. But does Ontario have any interest? If Canada is not going to be coming back to Ontario to recoup, does Ontario have any interest in how many annuitants Canada is paying?
I think that if they are being asked to pay an amount of money based on a certain number of people, that they do have an interest. And
But I'm saying if they're not being asked to pay, if Ontario is not being asked to pay, do they really care the number of annuitants that the Dominion pays?
although they were being asked to pay, I mean, in terms of as well of the pre-1892 period, where Canada was claiming for the amount of money that it had actually paid.
I guess what I'm trying to get at is understanding your description of the Dominion as being vulnerable because their numbers were too big. And other than being vulnerable to a complaint by Ontario that we're not going to capitalize on those numbers, is there any other reason why you would describe the Dominion as being vulnerable on their numbers?
Well, in fact, I don't know from the benefit of hindsight to what extent the implementation of the definition of the arbitrators of an Indian would have affected the pay list. But this was Canada's belief, which we can see in some of their internal documents. The other issue, I think, is not purely one of numbers, that Canada objects to Ontario coming in and making decisions into what it sees as its own area of discretion and jurisdiction, which is to manage these pay lists, determine treaty entitlements in its own view, and it does not want another government coming in and expressing its own opinions and making its own decisions.
Thank you. And that
Yeah.
gets me back to the earlier question I asked,
Mm.
because I can understand why the Dominion does not want Ontario meddling in the number of annuitants here for the purposes of the capitalization argument. The Dominion just wants to get this settled.
Yes.
But the way you've expressed it suggests that Canada was also very protective of its pay lists vis-a-vis Ontario for other reasons. Were there other reasons that Canada didn't want Ontario meddling in its pay lists?
Well, I think there is a numbers question, certainly, but there is
A numbers
also,
question being for the capitalization.
yes, and also even for past payments. But there's another issue at stake in that these pay lists over time have affected the way Indigenous communities have developed. And there is an issue of pure numbers, but there is also an issue of the kinds of effects that recasting of the pay lists would have for the families and the individuals who have considered themselves to be parties under the Robinson Treaty, the people in the actual communities themselves.
So Canada's actions in paying more annuitants than it was recouping for from Ontario and Quebec, or than it would be recouping for, was really a compromise. Would you agree with that? A compromise on the Dominion's part?
Yes.
It reflected Canada's decision that it just wasn't worth fighting with Ontario over the precise numbers. Is that right?
Yes, I mean, that makes it sound, I think, maybe like a smaller thing than it really was. Again, there are a number of issues, I think, both of principle and of administration that are at stake for Canada, that it obviously feels very strongly about, that it is willing to give up a precise accounting and a recoupment to which it might have been entitled in order to adhere to these other principles.
And what were these other principles?
I would say the principle that Canada alone has the decision-making power over who will be considered to be a beneficiary under the Robinson Treaty.
And other than, I'm trying to come back to the same question, other than the fact that you know, Ontario wants to keep the numbers low for this capitalization, for what reason is Canada so concerned about maintaining control over the pay list vis-a-vis Ontario? You mentioned because Ontario, I don't want to paraphrase what your answer was. Could you answer that question?
You know, I think there is a financial aspect to it, but I think that Canada, being in the day-to-day contact, especially by their field officers with the Robinson Treaty communities on the ground, has a better understanding over how these decisions over numbers are potentially going to affect their the people with whom they are treaty partners.
So what's the interest of Ontario in this?
The interest of Ontario, of course, is to keep the numbers down.
For the sake of the capitalization, for
Yes,
example.
and they
But
also,
beyond that,
they have a belief that Canada has not been interpreting the treaty correctly, that over time, Canada has allowed people to become treaty beneficiaries who should not have been allowed.
So I understand that's Ontario's position, but
Right.
why does Ontario even care? Other than for the sake of these annuities under the Robinson treaties, why does Ontario care how Canada manages its pay lists?
Well, I think that if Ontario had not been asked to pay, that it wouldn't care.
Okay, thank you.
You know, as it says, when the annuities were a lump sum that had already been capitalized, then it didn't matter. I think Irving says the same thing. But as soon as there is a per capita payment, then there becomes an interest in who exactly is being paid.
And so the converse of that is, if Ontario's only interest in the numbers is to keep them low for the purposes of capitalization, then Canada's only interest in protecting their own pay lists is to avoid this fight with Ontario about the capitalization. Isn't that right?
Well, again, I think there's broader principles at stake that, you know, Canada has had a way of doing things in the Robinson Treaty that has extended over the previous 50 years. Its decisions have real impact in communities. In a broader jurisdictional point, it does not want to concede that a provincial government can come in and interfere with its administration and control over this area of its jurisdiction.
Do you have any other evidence that Canada does not want to concede its jurisdiction over these pay lists other than this dispute for this capitalization?
You mean in terms of the Robinson treaties broadly, or are you thinking of other treaty areas?
In terms of the Robinson treaties, you've said a number of times how important it was to Canada to maintain control over this area of its responsibility, I guess. And you've told us that, well, in fact, I think I've gotten your answer on this point. I think I'll just leave it at that.
Okay.
We're talking about Canada's actions in paying more annuitants than it was able to recoup for as a measure of a compromise by the Dominion. Do you remember that?
Yes.
Would you also say that Canada's actions in paying the superior annuitants $4 per person, even though they knew they weren't going to get recoupment from Ontario and Quebec, would you consider that to have been a compromise by the Dominion as well?
Well, a compromise. I mean, I think from McRae's memorandum, which was his advice to the minister at the time, again, he referred back to the basic principles of treaty making, that the interests of the people in both the Robinson Huron and the Robinson territories were equally valuable to the Crown, and that his understanding of the intent at the time of the treaty was that both the people on both lakes would benefit equally from specifically the cash-related provisions. So McRae used those arguments to say, I think with that, regardless of what these statements say, we have a relationship under the treaty with the people from the Robinson Superior Territory that we need to continue, essentially.
Vis-a-vis Ontario and Quebec, though, would you say that the Dominion effectively compromised vis-a-vis its claim against Ontario and Quebec, saying, look, we're going to continue paying the superior annuitants, even though you're not willing to recoup? An option might have been for the Dominion to insist on a different look at the revenues, for example, to press this claim. That would have been an option to the Dominion, wouldn't it have been?
Yes.
And the Dominion decided not to pursue the possibility of revenues in the Superior Territory in order to recoup from Ontario and Quebec. The Dominion decided not to pursue that. Is that right?
I mean, you could say that perhaps the Dominion had a number of different options open to it at the time. The only one we can document historically is the one that actually happened.
So I thought it, in reviewing your evidence the other day, I found you put it very eloquently, I feel, when you testified about this issue of the number of annuitants, that all of the parties are so thoroughly sick of all these discussions on the province of Canada, which hadn't been in existence for over 25 years. They really want to get these accounts wrapped up and these negotiations concluded. Do you remember saying that?
Yes.
So are you familiar with the term realpolitik?
Yes.
Yeah, it essentially means a system of politics or principles that's based on practical rather than ideological matters. Is that right?
Yes.
And would you say that some of these actions by the Dominion really were motivated with a large measure of realpolitik as opposed to ideological considerations?
Well, I think you could also look at it in the way of a cost and a benefit. What would it cost us at this stage to continue some of these negotiations or to insist on certain principles? We can both defend our administration of the treaties, keep Ontario out of our business essentially, and continue to do what we think is the right thing to do anyway, in terms of making payments to Robinson Treaty beneficiaries, based on this settlement that we have in front of us. And it means that we won't get everything that we might be entitled to. On the other hand, we'll have a settlement and we'll come away with it with the benefit of being able to continue to make our own decisions as to how this treaty is administered.
Thank you.
Is that the same thing as something that is opposed to ideological considerations? Just how the question was put. They made, I think one of your lines was cost benefit analysis.
Mhm.
They made compromises.
So part of a cost and a benefit can be, we can have our principal, that's a benefit we perceive to us. There would be costs to pursuing that principle that may in fact outweigh the benefit that we can have right now.
Of some part of our principle.
Right.
But that's what I'm saying, is that the question was put to you, is that, I think Ms. Evans might have used realpolitik as opposed to ideological. You said, well, they included a cost benefit analysis, but I thought the distinction she was trying to make, and I wouldn't mind your opinion on this, was by the time they're thoroughly sick of things, they're not making decisions on purely ideological grounds.
Well, I think there still is there is a point of principle for Canada in that it believes at some level in the way that it has administered these treaties under its jurisdiction. It does not want another government to come in and second guess all its decisions. So it has, by agreeing to a settlement like this, it has adhered to that principle. And that to Canada would be a significant benefit. I think that that was perceived to be a significant benefit to Canada. In order to pursue further what might have been its legal entitlement to recoupment, it would have possibly had to give ground on that principle. So I think Canada was just not interested in doing that and regarded that as a significant downside towards perhaps getting a few more dollars.
Downside risk to its other view that it was entitled to more money.
Right.
Okay, thank you.
Was the amount of dollars that it could recoup really worth perhaps giving ground on its own administration of these treaties? And I think that Canada made the decision that it was not.
Sorry for interrupting. Go
That's
ahead.
fine. I want to move on then. You were asked in your evidence in chief about Professor Messamore's, your view on Professor Messamore's opinion that, and here I should say we're dealing with now the award 15 of the arbitrators, which really I would say memorializes those parallel orders in council. Is that a fair way to describe award 15?
It includes the orders in council, yes.
And these are the orders that set out how the capitalization amount and how it's to be paid, the other annuities, arrears, how they're to be divided between Ontario and Quebec.
Yes.
Okay, just to situate us. So Professor Messamore had given the opinion that, in her view, the Dominion would not have agreed to take on an unknown and unknowable obligation to pay the Robinson annuities into the future. This was in support of her belief that the Dominion understood that they were, at that point, the agreement among the parties, among the governments, had been with respect to annuities up to $4 per person. And Professor Messamore's opinion was, if there was an understanding that this was going to be unknowable annuity increases based on revenues, for example, it was her opinion that the Dominion would not have agreed to take on an unknown or unknowable obligation to pay annuities into the future, because doing so would be effectively adding to Ontario's debt ceiling. Do you remember being asked about that opinion?
Yes,
And you were asked whether the settlement between Dominion, Ontario, and Quebec would have had any impact on the debt ceiling, or we've also called it the debt allowance. Excuse me. And your answer was that you didn't see that it did. Is that right?
that's correct.
And you also testified that the arbitrators themselves did not appear to identify adding amounts to the province of Canada debt as having any effect, except for the additional charge back to Ontario and Quebec. Remember that evidence?
That's right.
So I put it to you that Justice Burbidge, Arbitrator Burbidge, was explicit in his view that if the Dominion could not recoup the amount of annuities that it paid from Ontario, it would be unfair to the other provinces of Confederation. Do you recall that, or shall we look at the?
Well, I think we should look
Decision.
at exactly what you're
Sure.
talking about.
So I'm going to ask my colleague, Mr. Fisk, to bring up the decision of Justice Burbidge, the February 13, 1895 decision. This was the decision that was then appealed to the Supreme Court. And it's found in a couple of different places. In fact, Mr. Fisk, can you use the actual document rather than?
Yeah, thank
It's
you.
reproduced, yeah. It's reproduced in the reported case, but I've actually, like, I know for your benefit, Ms. Jones, you want to look at the more original version. So, Mr. Fisk, if you could please bring up that Joint Book of Document tab 2693, you should have it there.
Is it also in the compendium by chance?
You know, I didn't see it in the
Okay.
compendium. Is this it here? Yes, here we are. We have it here. So it is Joint Book of Documents tab 2693.
Thank you.
And as I said, it's reproduced in the case report, but Ms. Jones, you're probably more familiar with this particular version of it. Do we need to go to the top, or are you satisfied with where I've got it? That here we're looking at Justice Burbidge's view. Maybe Mr. Fisk, you could scroll up a bit. This is only a 12-page document, so if you could scroll up a bit so we can see
Right.
exactly what we're looking
Right,
at.
mine starts at page 45, for example.
All right.
So you're starting at page.
And can I just ask, what are you referring to a version in your compendium?
That would be the version that is in the Joint Book of Documents.
Okay, thank you. I just wanted, if
2693.
you'd had it in your compendium, I would have notified Justice Hennessy, but we'll just use this version from the Joint Book of Documents then. So here, if you scroll down a bit, Mr. Fisk, we're seeing that this is the award. Stop there, thank you. The award of the arbitrators of the 13th of February, 1895, delivered actually on the 14th of February. This is the decision that was then appealed to the Supreme Court and the JCPC. And there are three sets of reasons. Chancellor Boyd goes first.
Yes,
And there's a very short concurrence, effectively, I guess, by Chancellor Cassot. Have I got that right? And then Justice Burbidge, not Chancellor Cassot, Arbitrator Cassot. And then Justice Burbidge speaks, starting at page, well, if you scroll down, you'll see it. Don't remember exactly where he starts his,
53.
maybe at page, yeah. Thank you, Mr. Fisk. This is good. It's helpful. So you would see
Cassot.
Cassot, his very short
Yep.
bit. And then if we scroll down a bit further, we see the Honorable Mr. Justice Burbidge's reasons for the award. And the part that I'm looking at now, just to set the context, all three of these arbitrators determined that this was a Section 109 trust issue, and it really should be, the augmented annuity should be the responsibility of the province of Ontario alone. Is that right?
Right,
Right. And of course, we know that that decision was overturned in the Supreme Court.
yes,
So here we're looking at Justice Burbidge's reasons, knowing that they were overturned by the Supreme Court, by a majority of the Supreme Court.
yes.
Okay, good. So if we look at page, well, it's 9 of the 12 document, 12 pages on the PDF, but if you can scroll down, Mr. Fisk, I think it was 52. Page 9 of 12, Mr. Fisk? Thank you so much. Okay. A little bit further down then. It's the page 9 of 12, so a bit further down. Okay, great. So now I'm looking at the paragraph that begins now. Now, looking to the particular matter, my mind lends a ready assent to Mr. Robinson's argument. Now, Robinson is for the Dominion, is that right?
Yes.
Okay. To Mr. Robinson's argument that it is equitable that this burden should fall upon Ontario. Ontario has the advantages resulting from the ownership of the lands, and it should bear the burden. I agree to that. Considered as a matter by itself, it is highly inequitable that any part of the burden should fall upon Quebec, and even in a greater degree inequitable that Nova Scotia or New Brunswick or any of the provinces that came into the Union since 1867 should be called upon as a part of the Dominion to contribute anything towards making good to the tribes entitled the increased annuities payable to them under the treaties mentioned. So I suggest to you here then, Arbitrator Burbidge is acknowledging the possible unfairness or inequity in if this obligation to pay the annuities were that of the Dominion only. This would effectively be sharing the burden then with the other provinces of Confederation, including Nova Scotia and New Brunswick. Is that not the point he's making here?
Or any of the provinces that came into the Union since 1867.
Yes.
So I think he could just as much here be talking about tax or other revenues than an actual increase in the debt allowance.
But the point being made, whether or not he's talking specifically or even thinking about it in terms of the debt allowance, I don't think that that's clear, and I don't think that that's really important for my question. My question really is, though, would you not agree that Justice Burbidge is considering that if the Dominion alone were responsible for increased annuities without the right to recoup from Ontario, it's really effectively requiring the other provinces to take on this burden, that it's really Ontario that has the advantages here, and yet the other provinces would be taking on that burden for Ontario's benefit. Isn't that the point he's making?
Well, he,
Yes.
The decision says what it says. Sir, can you turn on your microphone?
It says what it says, and she's asking the witness to speculate about what it might mean.
I didn't hear the question as speculation. I thought the question started, isn't that the point he is making? So I don't see in that speculation.
Well, Your Honor, my respectful submission is if the words on the page say what they say, they should mean what they say, and there shouldn't be any inference about what that means.
All right.
Other
And
than
you're
what it
saying,
says.
this witness didn't tell us what these decisions meant?
Well, she's putting other words that are not referred to here. To the witness.
No, your objection is that Ms. Evans is asking this witness what a paragraph means or what a point is. And you say a witness shouldn't be asked that. We should only look at the words on the page.
She's asking her to hypothesize about what the Justice Burbidge was meaning by the words on the page, other than what they say.
Ms. Evans?
I can change my question and put it this way. When you testified that the arbitrators themselves did not appear to identify adding amounts to the province of Canada debt as having any effect, on other provinces, would it change your opinion to see that Justice Burbidge actually mentions this point in his decision? He shows some concern about the effect on other provinces.
well, I see that he starts out that sentence by saying it's considered as a matter by itself. So I'm now just reading on a little bit further, because that seems to be, he's saying, if you looked at it that way, it could be considered that, but he goes on then in the rest of the paragraph to add to that statement.
He goes on in the rest of the paragraph to discuss the difference between equity and law effectively, and says that really this is a matter that I think we should consider an issue of law that we'll put before it can be appealable, we'll let it go before the Supreme Court. So, and I acknowledge, of course, the Supreme Court reversed him. That's not the point, whether Justice Burbidge was right or not, but the point is, this issue about the effect on other provinces was put before the arbitrators. We could also pull up the transcript to show that, but effectively, the fact that Justice Burbidge adopts the submissions of, or at least shows some acknowledgement of the submissions of the Dominion on this point. The point is to suggest that this wasn't a foreign concept to the arbitrators. The fact that if the Dominion were to bear the responsibility for these augmented annuities without the ability to recoup from Ontario, that would have an effect on the other provinces. Would you agree with that?
Although they go on to make decisions that don't explicitly take that element into account, which is what I was referring to.
But do you
In-
agree with the proposition that that Ms. Jones, or Ms. Evans, sorry, just put to you?
Well, he seems to be qualifying this statement. I mean, he does refer to this overall concept, but then he qualifies what he's going to say. He said this is an argument which might seem on its face to have some merit, but then he goes on to say, but it was the union of the provinces was a large matter involving many issues and consideration of great moment. What one might think to be fair and equitable with respect to a particular matter dealt with in the Act, abstracted from the other provisions therein, might in conjunction with such provisions be in fact and reality unfair and inequitable. So he's saying that he's setting it up really as the first half of a sentence or a proposition. He said you could say that on the face of it, it might be unfair, but on the other hand, there are other considerations in looking at the British North America Act and the way it is playing out that might mean that it is more fair than it appears on its face. Or he's saying that if one takes only one view of this particular aspect, then something might seem fair, but it is in fact in the working out of it, it would be unfair. So in a way, he's setting it up, I think, a little bit as a straw man. You know, are you saying, is he acknowledging that this could be an argument that would be made in this paragraph that you've pointed me to? Then yes, I would say he's acknowledging that this is an argument that might
Thank
be
you.
put forward.
Thank you. I think Ms. Glasser is correct that the actual legal interpretation of this, specifically as it gets into issues of equity versus law, is something that the lawyers and Justice Hennessy can deal with. My only point was to have you confirm that in fact the arbitrator was considering the possible effect on other provinces, and I think you've given me that answer.
Although it may not be in the context of the debt allowance, which is, I think, the way you began the line of questioning. It could just as easily be a question of the taxpayers of these other provinces bearing some of this burden.
But would you not see that if the Dominion took on responsibility for augmented annuities, that this could potentially be really taking on a debt of Ontario's, is one way to look at it. It would be taking on a debt of Ontario's. In fact, absorbing and assuming the debt of Ontario, which would really have the effect of increasing Ontario's debt allowance, would it not?
First of all, you would have to ascertain that it was a debt of Ontario, which I think is part of the point of all of these Supreme Court decisions and maybe why we're in this courtroom today. So I don't think you can just assume that as the first part of the sentence and then go on to speak to the second part of the sentence.
Thank you. Those are all my questions. Thank you, Ms. Jones.
Thank you, Ms. Evans.
before I begin, is it the court's preference to take a break now, or I can go for 10 minutes? And
I was going to ask you if you had a preference.
I do not have a preference at all.
All right, let's start. I should ask the witnesses, are you okay if we go for 10 minutes before? a break?
Sure.
Thank you.
Okay, so we have a compendium to hand up, which is going to guide the cross-examination. And I wonder if I can provide a copy to everybody. And I understand that aside from one tab that has statutory material, everything else is a trial exhibit already.
Thank you.
And there are 8 tabs in the cross-examination compendium. And we'll have one for the witness.
Got one.
Okay, you don't need to go there yet. I'll direct you when you need to review it. I'm not going to start it. I just wanted to, spend a couple of minutes just organizing things for, I hope, an efficient cross-examination. Should this be marked as exhibit, lettered exhibit? And I'm not sure what number we're up to. Letter.
What are we at?
HH. All right. So we're going to call the compendium HH. Ms. Jones, my name is Harley Schachter. We've met before, and I've got some questions to ask you today, okay?
Hello, Mr. Schachter.
Hello. Now, I want to preface my questions by saying that a lot of the questions I have for you, I might not think are relevant, but Ontario has asked a lot of questions and had you give a lot of evidence about things that I don't understand the relevance, and maybe I'll understand it when I see their argument. But my job today is I want to make sure that the court has the benefit of the facts being correct. And so I'm going to ask you some questions that I hope are going to clear up some factual inconsistencies that I hope is going to be of some benefit to the court. So the first place I want to start is that just some general themes about your report itself. Now, you would agree with me that your report is only part of the evidence that the court is going to consider, correct?
Yes, absolutely.
And you would agree with me that you do not claim to speak for or instead of the Anishinaabe in this case, correct?
That's right.
And you are aware of the need to make space for the Anishinaabe voices.
Absolutely.
And you would agree with me that the existing documentary record on which your report was based, especially as the report was focused on disputes between Ontario, Quebec, and Canada, greatly underrepresents Indigenous perspectives and voices. You'd agree with that?
That's correct.
And you would agree with me that the narrative of the implementation of the Robinson Treaty's Annuities Clause that you have placed before the court in your report provides in itself a demonstration of the marginalization of Indigenous peoples. Would you agree with that?
Well, yes, in that the particular questions that are being asked in this report have to do really not so much with the Indigenous peoples, but with the relationships between Ontario, Canada, the province of Canada, and the province of Quebec. So both in the documentary record that underpins the report and in the focus of the question, the perspective or the perspectives past and present, I might say, of the Indigenous people are at the margins of this report.
All right, thank you. I wonder if we could go to the compendium HH in tab 1. Tab 1 is part of exhibit phase 3 1-2028. And you remember in direct examination, you were talking about the 5th column from the right hand side, the one about payments to Indians.
That's right.
And there was a discussion about the amount being deducted being the annuity amounts or the fixed annuity amounts originally promised in the treaties.
Yes,
The 500 pounds in the case of the Robinson Superior Treaty, which is equal to $2,000, correct?
right.
And I had thought that there was some, I don't want to call it, well, I don't know if I should call it confusion or querying. Why did they only do the $2,000 and not the money actually paid? Is that, did that come through, or was I just sort of reading between the lines improperly?
Well, after 1875, the Dominion of Canada is paying more than $2,000.
Yes,
Yes.
but I thought there was some discussion between perhaps you and the judge about they've only deducted the 2,000. Why haven't they deducted what they're actually paying? And I think that you and I are going to, I hope you will agree with what I think is the right answer. Would you agree with me that the purpose of the data in Exhibit 1-2028 at tab 1 of the compendium is to try and figure out whether any augmentation above the $2,000 per year is due and owing?
Yes, that's the purpose.
So you wouldn't include in, if that's what you're trying to calculate, you would not include in amounts payable over and above the 2,000 because you're trying to find if that floor should be exceeded, that floor being 2,000 per year.
Right, but then of course, if you have a surplus, then there will be presumably some measurement of how much additional will be paid
Yes.
before a loss is incurred.
Uh,
So you can say that in some of the later statements, we might see this is how much was actually paid.
Yes.
The point, as I understand it, is to calculate how much can be paid without incurring loss. So in that respect, the actual amount paid is going to be relevant at some point.
At some point, but the purpose
Right.
of this document was to see if you could get over the floor of $2,000, $2,000, correct?
Right.
Now, we're also going to need your slide deck. If you could go to your slide deck 37, number 37. And the next couple of questions have to do with section 118 of the Constitution Act 1867 and what its role in these proceedings might be. Now, you'll recall that you spoke at slide 37 and at about section 118, and I don't believe that's actually in your report though, is it?
I did refer to section 118 and the subsidy.
All right, so
Uh,
this is part of the story about Confederation and how there was a grants under section 118 to defray the costs of the civil service and the costs of government, I think is the words he used.
Right.
And what I wanted to do was to sort of just follow this through and see what happened to 118 so we have a proper historical picture of it. And I'm hoping that you have some expertise to help guide the court with this. Now, I might add that Barbara Mesamore discusses section 118 at her report at page 64. Now, if you'll go to my compendium at tab 2, you will find excerpts from the of the Constitution Acts, which I took off the web page the other day, and it's from a Government of Canada website.
Right, I recognize this.
You recognize the typescript, I imagine.
Yep.
And I'm going to come back to the first part of it, but I'm going to go over to page at the bottom right-hand side of this document, being the compendium HH, there are numbers. That's the numbers of the compendium. And if you go to page 8, where paragraph one, section 118 of the Constitution Act 1867 used to reside. Can you see the,
Oh, this is the section on,
well, it's old section
Subsidies.
118. It says repealed is all it says on the
Right.
page.
yes,
Right. So, and you see it says footnote 59.
right,
So we're going to go over to footnote 59, which is at the next page, page 9 of the compendium. And there's a little bit of a story to tell about section 118 that I hope you're familiar with. I imagine you are. It might, is that fair that you know
Well-
something about 118?
to some extent.
All right. So section 118 ended up actually being first amended in 1907 with an amendment to the Constitution Act in 1907 when the amounts were increased. And you'll see at footnote 59 in the about 3/5 of the way down the page. There's the heading, the section was made obsolete by the Constitution Act 1907.
Right,
So what happened is that section 118 had certain allowances in it. And it was amended with new numbers in the Constitution by the Constitution Act 1907,
yes,
correct?
yep,
And then as per the beginning of footnote 59, it was repealed in 1950, correct?
correct,
And the reason why it was repealed was because the government started doing something called equalization.
right, yes,
And that equalization, as page 10 of the compendium shows us, it, is now found in actually the Constitution Act 1982 under section 36 of the Constitution Act. You'll find that at page 11 of the compendium. You know that it's now enshrined as part of the Constitution.
yes,
And there is also 2 other acts. If you go to page 10, that I understand are still in force. And this is about 1/4 of the way down on page 10. It says, see the Provincial Subsidies Act, Revised Statutes of Canada, and the Federal Provincial Fiscal Arrangements Act, which also speaks of equalization. Is that correct?
yes. Now, I can't give you the current status of that legislation or what's in it, but I am aware that there was legislation about the subsidies and the fiscal arrangements.
All right, so my question, and then we'll take a break, but my question has to do with section 8, or I'll paraphrase it first. As I understand the history, section 18 eventually morphs into what is now equalization payments.
Section 118.
118. right?
118.
Yes,
Well, the whole financial structure as set out under the British North America Act is different today than it was in 1867 or 1895 or 1896. It's a different structure based on different arrangements.
all right. So one of the things you understand that the provinces report to Canada about when they're in their discussions about equalization is what kind of revenues they get and keep from resources. Are you aware of that?
I can't say that I'm aware of the nuts and bolts of how this is actually done. Provincial budgets are a matter of public record. So that information would be accessible.
Okay, so you're not familiar with the workings of equalization?
Well, I've never been for example, as an Ontario civil servant, I was never involved in those negotiations. So I don't know exactly how they work.
Yeah, the reason for me going through this was to get to the question of, can you provide the court with any help as to what relevance section 118 flowing through to equalization might have for the court's deliberations about what to do about this phase 3 and the revenues and expenses of Ontario, like just generally. Is there some help, some expertise you can bring to help the court try and unpack what the relevance of these sections are?
The relevance of the sections is that it's what was in force, say, in the 1870s, when there were discussions taking place between Ontario and Canada about the implementation of the augmentation clause of the Robinson Treaty. The person, Mr. Mowat, who was the Premier of Ontario and offered his opinion at that time, had been involved in the drafting of the British North America Act and the Quebec resolutions. And it was also the structure that was in place in the 1890s when the subsequent arbitrations and court decisions and decisions on, say, the administration of some of these intergovernmental financial matters were made. So it was relevant to their data sets and how they were making arrangements at the time, making decisions at the time.
Have you turned your mind at all as to whether the equalization payment structure in Canada has any bearing on a sharing arrangement that the judge might decide upon as between Ontario and Ontario's resources?
Objection, Your Honor.
Go ahead.
Ms. Jones was qualified to give evidence as set out in her in the qualification agreement at the beginning of the examination. Equalization payments current purpose of the Constitution Act.
My only concern is that the witness and Ms. Messmore both raised section 118. I'm still not sure I understand why it's relevant, and I'm hoping to see if it is. If they know anything about it. If they don't, then it's not relevant and I can move on.
The arguments that Ontario makes regarding section 118 are coming when we get to police. The witness to tell what the relevance of the arguments might be.
Well, I don't recall Ontario's pleadings letting me know what it is, so I'm kind of in the dark trying to give the court help. If section 118 does have relevance for Ontario, and if this witness can help the court, that's fine. If this witness can't, we'll have to look at that.
The question, as I understand it, is, have you turned your mind at all as to whether the equalization payment structure has any bearing on the sharing arrangement as between Ontario and Ontario's resources? I don't think that's asking for an interpretation of section 118, asking about that relevance. This witness referred to section 118, appears to know how it works. There were questions asked of her. I don't recall the question asked of her in that regard, but I don't find this question problematic. I'm not listening for an interpretation of section 118, which would appear to be your objection. I don't hear that asked for. And yes, she's not qualified as an expert in what section 118 means, but none of that is captured by the question.
So Mr. Shacker had asked about equalization. the objection was and arguing about the relevance of such how technique there.
I only am noting your objection to the question that I just repeated. Have you turned your mind at all as to whether the equalization payment structure in Canada has any bearing on a sharing arrangement that the judge might decide upon us as between Ontario and Ontario sources?
That would maintain that she has not provided any evidence and versions of the Constitution Act.
I don't have a problem with the question.
Okay.
You want to ask it again?
I couldn't if I tried. Not without my friend being able to give me that. Okay, let's see. I'll go and try and find it.
At 11:38, 48.
Okay. Okay, I'm at the bottom. Okay. Okay. Have you turned your mind at all as to whether the equalization payment structure in Canada has a bearing on the sharing arrangement that the judge might decide upon when we deal with Ontario's resource wealth? I'll rephrase it that way.
And I have to say, I have not turned my mind at all to that particular question.
While you may not have turned your mind to it, on the stand today, are you able to, in your opinion, with your expertise, provide any guidance to the court on the subject?
No.
All right, thank you. That would be a good time to break.
Thank you. Thank you. 15 minutes.
All rise. For recess for 15 minutes. This court members, you may be seated.
Ms. Jones, we're going to turn to some areas that deal with what I think are perhaps some imprecisions in your report that maybe I can get you to agree with me that they are imprecise, and we'll fix them up. And the first area has to do with the increase of the Robinson Treaties to $4 per capita. And maybe we can do much of this without needing to go to the documents themselves and see if you agree with me. So in 1873, Dawson writes and asks for not simply $4 per capita, but for amounts greater than that, correct?
Yes, that's correct.
And when that request goes to Sprague, Sprague ultimately prepares a memo to go to Ontario in which Sprague writes, the Indians of Lake Huron and Superior claim the fulfillment of the above quoted stipulation, he's referring to the treaty, to the extent of $4 annuity per capita. You recall that, or do you want to
Right.
look at
Now,
it?
are you referring to the copy of, sorry, Sprague's memo that was actually sent to Ontario, or to his original
No,
memorandum?
the memo that was sent to Ontario, which I believe you'll find at the compendium page 16. It's dated August 9th, 1873. The bottom right-hand side, it's at tab 3, page 16 of the compendium. You'll find Sprague's August 9th, 1873 memo, which is his abbreviated memo.
I'm going to find it in the original.
And what I was looking at was the middle of the page, the second paragraph, the Indians of Lake Huron and Superior claim the fulfillment of the above quoted stipulation to the extent of $4 annuity per capita.
I'm almost with you here.
Yeah,
And what is page 16, Mr. Schachter?
page 16 is Sprague's second memo of August 9th, 1873, which I was just trying to get the witness to confirm is the version that was eventually sent to Ontario.
Thank you.
Okay. It should be attached, actually attached to an order in council, which was sent to Ontario. If I can find that. Okay, this is it. I think tab. Is it 2691 is the package that's in Ontario's records. And there's an order in council and there is Sprague's condensed memo. So now you are looking at a paragraph that begins,
Are you able to first confirm the condensed memo is the one dated August 9th, 1873?
the one attached to the order in council is dated August 9th, 1873.
Thank you. And does it have the words, the Indians of Lake Huron and Superior claim the fulfillment of the above quoted stipulation to the extent of $4 annuity per capita?
The Indians of Lakes Huron and Superior claim the fulfillment of the above quoted stipulation, which is the augmentation clause plus the diminution clause, to the extent of $4 annuity per capita. Yes, that part.
Right. He
Per
might,
capita.
does it say per capita? Or
Yes.
per capita?
Per capita.
Okay. So other than that one change, you would agree with me?
Yes, so far.
Okay.
So the agreement is that this condensed memo of Sprague went to Ontario.
It's in Ontario's records, so they received it.
Right. And it was sent together with the order in council.
Yes.
Now, if you go to page 15 of your report, please. The first point I want to make about the documents we were just looking at is that what did not go to Ontario is Dawson's letter.
That is correct, yes.
And what did not go to Ontario is the petition, correct?
I believe that's correct.
Okay. Now, at paragraph 1 on page 15 of your summary, this is part of your executive summary,
Yep.
part VII, you say in 1870 and 1873, Robinson Treaty beneficiaries petitioned for an increase in their annuities based on the augmentation clause of the treaties. First thing I want to point out is when you say 1870, you actually mean the petition of 1869 from the Huron side, correct?
I'm thinking of the one that was forwarded by Plummer
Yes.
in 1870 to
Right,
the department.
Plummer, I'm going to submit to you that what Plummer does in 1870 is attach an 1869 petition from some Lake Huron chiefs. Would you agree with that?
Let me just check that that is the case. Yes, that's right. There are there's more than one petition. One is dated June 1869. There is also part of that petition that's dated July 1870. And there is another petition dated July 1870.
So those three petitions in 1870 were forwarded by Plummer up the chain, correct?
Yes,
And in the third line of item number 1, you said Canada, second sentence, you say, Canada received these petitions. That much, I think, we agree. There's no
Yes.
dispute about that.
yes.
You then say, and forwarded them to Ontario. And that's not true. It's not correct.
Let me just double check that. I have the copy of the order in council here, which does not have the petition, but I just want to be sure that there's no reference anywhere else to a petition.
Where, Mr. Schachter, are you
I'm on
page 15 when you said forwarded them on to Ontario?
Oh, page 15, item number 1 in the summary.
Yes,
The exact words are used in the report are Canada received these petitions and forwarded them
got it.
to Ontario.
Thank
And
you.
I'm trying to get the witness to confirm that what Canada forwarded to Ontario was Sprague's memo and an OIC.
Thank you.
Yes, I believe that's true. Yes. Thank you for noticing.
Right, I
That
think
in
what
the
you were trying
summary.
to say is that the gist of what they were, or their complaints were somehow forwarded, and we now know exactly how it was forwarded.
Right.
Perhaps we could go to page 74. Now, at page 74 in your report, there's no paragraph numbers, but once to the July 9th. It's at page 75. I apologize for the document I was using to prepare for your cross-examination is off by one page number throughout. And so it's the one that's been filed as an exhibit, it's page 75.
Right.
And the third paragraph, this is where I want to take you to, and it's involving the story, if I can put it at that, of how Mowat in 1874 for Ontario actually responds to the communication from Canada. And you say this order in council was referred to the Attorney General for Ontario. And that's this being the order in council of July 9, 1873, correct?
Yes.
And then you write correctly, Mowat wrote a memorandum referring to the order in council 9 July 1873.
Right.
And then you record what he wrote in respect of July 9th, 1873 memo.
Yes.
Now, let's flip back to page 72 of your report. It might end up being page 73, but just bear with me for a moment. It's going to be at page 73. The paragraph, this order in council. Do you see that in the middle of the page?
Yes.
Now, again, this order in council is referring to the 1873 order in council.
Yes.
And you write, this order in council was forwarded to the Lieutenant Governor of Ontario, substituting an abridged version of Sprague's memorandum on 22 August 1873. We've already gone through that.
Yes.
And then you say, you wrote, sending orders in council was a customary method of communication between federal and provincial governments at this time. And you write, no reply to the order in council of 9 July has been located to date. And really what you meant to say there, I think, is that Mowat didn't respond to the July order in council until after Canada had sent the 1874 version or request.
Yes, I think that's fair. I think what I was thinking of was there any response from Ontario before 1874 when another order in council was sent?
Right. And so what Ontario actually, Mowat for Ontario actually responds to is the 1873 order in council. He never responds to the 1874 order in council.
Well, unless you consider that the reason that Mowat responded to the 1873 order in council was because he had got another order in council from Canada. And the references to the earlier order in council, that's true, but I think that it might not be unreasonable to assume that his having received another order in council from Canada might have prompted him to go back to respond to the first one.
Have you looked into the differences in the two communications between as 1873 as opposed to 1874 from Canada?
Yes.
That there's differences?
Yes.
And would you agree with me, without having to take you through the documents, that the 1874 communication does not limit the request to $4?
In 1874,
The one that Mowat doesn't respond to.
yes, the 1874 communication simply refers to inviting the Ontario government to enable the Dominion government to make such increase in the annuity, thereby secured to the Indians, as they may be thought entitled to under its provisions.
Right, well, and let's just go, we can refer to that at page 21 of the compendium. There are 3 statements that Hemsworth records part of the order in council. In the first paragraph, in the 4th line, this is at compendium page 21. He advises what the Indians were claiming in 1874. And it says, on a memorandum dated 17th June 1874 from the Honorable the Minister of the Interior, stating that Mr. Boron, Member of Parliament for Algoma, has submitted on behalf of certain Indian bands on Lake Superior, parties to the so-called Robinson Treaty concluded in 1850, their claim to have the annuity granted them under that treaty increased in accordance with its provisions.
This is now the 1874 one that
Yeah.
you have there.
Yeah. We're just looking at the same order in council. I don't know where you were reading from, but I'm just reading from a version of it.
Okay, that is the 19th of June. I
It's
am,
dated June 19, 1874.
right. Once again, I'm going to pull up the original. Oh, let's see. Oh. Where is it? Oh, it's the 19th of June. Okay. Now, the clause to which you are referring is,
It's in the first paragraph
Yes.
of the OIC.
right. Right. So, yes, I have that.
Okay,
So there's a question.
so you would agree with me that the first paragraph includes in a reference to boron for Algoma member of parliament for Algoma advancing their claim to have the annuity granted them under the treaty increased in accordance with its provisions.
Yes.
And there's no reference to limiting it to $4.
Although I think Boron's original letter may make a reference to that. But
Well,
in this order in council, so far, there's no reference to it.
okay, well, not only so far, nowhere in this order in council is there a reference to it. A $4 cap.
In the order in council. Yes,
Thank you. And in the communication to Ontario, which includes in a copy of the treaty, a copy of the Minister of Interior Laird's memo of June 17, 1874,
yes.
and a copy of the order in council of June 19th, 1874. There is no reference to only requesting an increase to the extent of $4.
That's correct.
All right, so if we can go then to back to page 15 of your report. And again, I think this comes under just of a slight correction to your report. At page 15, you have it item number 2. You say, in 1874, another request was received by Canada for augmentation in the annuity. Canada again sent the request to Ontario. The Attorney General for Ontario, Premier Oliver Mowat, produced an opinion in response. And to be clear, the response that he gave was not to the 1874 communication. It was to the 1873 communication.
Again, I can't, I think he may have produced this memorandum, which was sent to Canada in response to the fact that he had received another order in council from Canada pressing the claim that this may have caused the province of Ontario to realize, I suppose, that Canada was actually expecting an answer. The previous orders in council were quite vague about, you know, submitting something for Ontario's consideration, or that, you know, that they would take such action as would be considered appropriate, or some equivalent language. But to receive another order in council from a different governmental administration, and I might say one of the same political stripe as the government in Ontario, Mowat might have thought, well, I think they're serious about actually expecting an answer.
Right. You're surmising what might have happened. You don't have evidence that that's what happened.
I think it's not an unreasonable set of facts to assemble to say that this could have been the case.
Isn't it unusual to not reference in a communication at that level what order in council you're replying to?
Yes, you know, they again, they could have been prompted to respond to the 1873 order in council because they had received this follow-up order in council.
Right,
Yeah.
but to be clear, the Mowat's response does not reference the 1874 communication.
Yes,
correct?
that's an accurate way of putting it.
Thank you. Now, under the, let's move on then to under the heading of, I'm not sure why this is relevant, but I want to get the facts correct. Can you go to your slide deck 79, please? At slide deck 79, you talk about some statements provided by Canada to Ontario. And in the first bullet, you say in the third line, these statements generally showed an excess of revenues or over expenditures. And what you meant to say is that these statements generally showed an excess of expenditures over revenues, the exact opposite. You just made a mistake.
Oh, well, let's look at those again.
Well, why don't you just look at your report? Because I think you got it right in the report.
There should be a joint book.
If you look at page 116, if I can help you, page 116 of your report.
Right, I'm just looking at there should be a joint book reference at the bottom of the slide. there.
It's going to be trial exhibit 1-2966.
2966.
We're not going to turn it up.
It should be,
And we've got on the computer your page 116 of your report, where the opposite of what is on slide 79 is
Yeah.
communicated.
receipts.
Yes, oh, sorry.
Pardon the interruption, Ms. Jones.
You've got it?
It's
Rachel?
2966, I believe.
Well, there is a reference at the bottom of the slide, but the reference on the bottom of the slide is incorrect. So I'm trying to give you the correct document that I think
Okay.
I believe you're referring to, and I found it by going to your report, not the slide deck. It's at footnote 238.
Yes, you're correct in that it does show that there are some years where the receipts exceed expenditures. If you look at the total at the bottom, the expenditures do exceed the receipts.
All right, so that's just somehow you just switch the two around in the slide deck.
All right.
You would agree with that?
Yes, again, there are some years in which receipts do exceed expenditures, but cumulatively, expenditures do exceed receipts.
Now we're gonna, I think we might come back to that exhibit later, but still under the heading of just wanting to correct what I thought were, I don't know if they're typos, I hope they are, but if you go to slide 95. You were referring to the January 7th, 1898 order or order of the arbitrators. And you were talking about the burden of proof regarding proof of who's on the pay list. Do you remember talking about that?
Or whether they are entitled to be on the pay lists.
Whether they're entitled to on the pay list. And you've paraphrased what the actual document says, and you say, for additions on the Indians for those who act for them.
Or for those who act for them. I think
I
that should,
believe you meant to say on the Indians or those who act for them, right?
yes. Yes.
So there's just an extra F there.
Yeah.
And you referenced that at page, being at page 142 of your report. And I was hoping I'd get the correct verbiage from page 142 of your report, but there's another small error there as well, I think.
So that was the first line of the first bullet
Yeah,
on the Indians or, Or
instead of
those-
for, it should be or.
That's right.
thank you.
Oh, sorry, try page 143. So you've tried to reproduce the quote verbatim at page 143, but there's another small typo, I hope. You write the onus of showing that the names of any individual entitled to be reckoned were improperly omitted from such lists shall now be on the Indians or whose.
Those.
It means, you meant to say those.
Yes, I did.
Yeah.
I apologize for
No,
that.
you don't have to apologize. I just want to make sure that it's just a typo and there's nothing more serious going on. I
No.
know you're so particular with your words. I want to make sure. Now, sort of sticking with the 1895 order. If you look in the compendium at tab 4, I hope this is a version you can work with. I got a copy, I think, of that 1895. Oh, no, wrong one. Sorry, my apologies. We are indeed moving to 1898 and the
Yes.
January 7th award of Order of the Board of Arbitrators. You'll find a copy of it at tab 4, page 23 of the compendium, and I'm hoping you can use that version.
Yes, I have the original documents, but I was also using this compendium because it is easy to read and it's handy to have everything together. Seems to be reasonably accurate.
Okay, and this award of the Board of Arbitrators is an excerpt of Stage 3 Trial Document 1-2609, and it's pages 24 to 26 of that document. And it's found at tab 4, page 23 of the compendium. And just to help us situate ourselves as to what we're talking about, this is the award that talks about the burden of proof we were just talking about.
Yes,
And it also is the award where the classes of expenditures are set out by the arbitrators.
now technically this is an order, not an award.
Okay, thank you.
The award precedes it, but then there are these orders which council, on areas in which council had requested direction.
All right, now, would you, and on page 24, you'll see the actual wording of the onus provisions we were actually just discussing under the heading burden of proof.
Yes.
I'm just trying to situate ourselves in the document. Then when you go over to the page 25 of the compendium, under the heading 3 classes of expenditures to be taken into account in determining if augmentation of annuity can be made without incurring loss, and there's a list of 1 through 14. See that?
Yes,
Now, would you agree with me that although this is an order of, as you put it, of the arbitrators, Canada in the arbitrations basically agreed to these categories of expenses that Ontario put forward?
we know there was discussion between Ontario and Canada. There were arguments presented to the arbitrators, which led to this order. I don't know the extent to which I can say, I can opine that Canada and Ontario had agreed upon this list. This is mostly Ontario's list.
All right. So I have with me the proceedings in that arbitration.
Right.
And so I guess I don't want to take, I don't think I need to take you through it. What, if you're not able to say that Canada basically agreed to what Ontario wanted, you don't feel you can agree to that?
Well, not without allowing myself to revisit the issue
All right,
again.
well, I'll save that for argument then.
All right, the answer you did get was this is mostly Ontario's list. Is that correct?
Yes,
Yeah.
Ontario had proposed a list. Not all of Ontario's list made it into the order, but almost all of it did.
What of Ontario's didn't make it in?
There's some, I'd have to compare them to give you an exact accounting for that,
Well,
but
we're gonna have to do that because I'd like to know what it is you say is different between what Ontario asked for and what they got. If you say they're different.
so I think in my report, I did reproduce Ontario's list. And some of it may be differences in wording rather than substance.
Yes, I think that might be fair.
Yes.
Can we leave it at that, or do you need to go further?
I can find Ontario's proposed list, I think, fairly quickly.
I'm trying not to be overly pedantic about this, but
Okay.
my point is that, yes, there are differences in, slight differences in wording,
Yes.
but in substance, Ontario's list that the Ontario's list is pretty much the same list as the arbitrators ended up deciding upon.
Well, I'm looking at a letter there are a couple of different places to find what Ontario proposed. One is in my report at pages 108 through 110, which is a list that Premier Mowat sent to Canada's Minister of Justice, Mr. Thompson, in 1891. And,
Let me interrupt. Maybe we're talking at cross purposes here.
okay,
Because when I talk about the list that Ontario asked for, I'm talking about the list of expenditures they asked for at the arbitrations
Right.
orally in argument is what the arbitrators eventually awarded, subject to some word changes.
yes, yes.
You would agree with that?
Yes, I would.
Okay, so thank you. Now, in terms of revenue side, you would agree with me that early on, and when I say early on, I mean 1893, Canada had included as a revenue stream customs duties. Do you remember that?
Yes.
And now, can you help the court with why Canada thought customs duties were a revenue to be considered?
Well, because I would assume that they had thought that customs revenue could be relevant. In other words, that there would be some revenue there. The port of Sault Ste. Marie was referred to as a free port. So I think that meant that some of the normal fees that would be levied on the port were not levied at Sault Ste. Marie. So I don't know how large, but obviously the seaports are the points of import and export where
Also,
there
the
would
Great
be
Lakes
most
with
customs.
Thunder, sorry, I don't mean to talk
Yeah.
over you. Would Thunder Bay also be a port where there'd be customs duties going to the United States?
Yes,
Or customs duties received from transactions with the United States?
yes,
Okay, but the question I was trying to get at was Canada in 1893 did put forward that one source of revenue might be customs duties.
yes.
And I was wondering if you could help the court with, if there's any record that you found explaining the thought process that officials had as to why customs duties might be included in as a revenue source.
Might be included.
Yes.
I don't recall anything now, or in fact, why they were not included in the final tabulation.
If I had a document to show you that I could
Okay,
tell you, I would show you, but I truly could not find an explanation as to why Canada was advocating for it, and I was hoping you might have some guidance.
no, the only things I can recall are the discussions that take place in those transcripts that you just showed
Okay.
by among the parties as to what classes of revenue might be allowable and to what extent.
All right, certainly then by the arbitrations in 1897, no one's talking about customs revenues anymore. Is that fair?
That seems to be the case, yes.
So, sorry, the questions were in terms of revenue. You would agree that in 1893, Canada included customs duties? The answer was yes. And the next question was, why did Canada think that was relevant? Customs duties relevant?
I was looking for anything that might help understand the corporate mind of the Crown as to what it is, why they thought it was appropriate to include in customs duties. And the answer was she didn't know.
Right, but then you say by 1897, they're not included?
By 1897, when the Ontario and Canada get to the arbitrations,
Mhm.
there's no mention of it anymore.
That's correct, yes.
Thank you.
That's the best story I could figure out as well.
I
And-
haven't
and-
got anything to add, really,
And your answer was, I don't recall anything now on why they were not included.
or why they were proposed in 1893,
Okay, so both ways.
right?
Thank you.
Right, now I want to go to tab 5 of the compendium, which is, should contain in the 1895 decision of the arbitrators, or maybe order. This is, I've got exhibit 1-2018. And I wanted to take you through some portions of this because I think we want to have a complete picture of the facts surrounding the arbitrations for the judge to consider. So if you'll bear with me, the first thing that I want to go to is paragraph 142 of the BNA Act, which is at page 29. Of the compendium. You see that?
Yes,
So I'm correct in understanding that the arbitrations that happened in 1895 have to do with section 142 of the BNA Act, correct?
well, to be honest with you, I'm not sure. 1870 seems fairly straightforward. I did notice in the preambles and the legislation around the 1891, 92 arbitrations, when they were being set up, that section 142 is actually not referenced.
So you're not sure if section 142 has anything to do with the arbitrations of 1895?
I'm not sure I can express a definitive opinion on it.
Okay, that's fair. Let's move on. Now, if you can go to page 36 of the compendium. Now, you will recall that you were discussing with Canada's council how Quebec's representative resigned, and you're probably familiar with the story of Quebec trying to, I think they even tried to take away his commission, the commission of their own appointee to try and prevent the arbitration decision from going ahead.
Yes.
Do you recall that? But to complete the story, what happened with that is that the matter actually was submitted to the Judicial Committee of the Privy Council in 1878. Do you remember that, or do you know
Yes.
that?
Yes,
And what this document at page 36 of the compendium is the decision of the Privy Council,
yes,
and you're familiar with that, right?
yes,
And so we see the Queen, the Privy Council and members, the Lord President, the Lord Chamberlain, the Earl of Derby, Mr. Watson, I presume, Duke of Devonshire. Thank you for laughing at that. I appreciate that. Lord Privy Seal, and Lord President. And the second paragraph, it says, Your Majesty, having been pleased by your order in council, and that's referring to an imperial order in council,
yes,
of the 22nd December, 1877, to refer unto this committee, that's the Privy Council,
yes,
a matter or special case concerning the validity of an award made or purporting to have been made in an arbitration between the province of Ontario and the province of Quebec in the Dominion of Canada under the British North America Act 1867 for hearing and consideration, and to order this committee to advise your majesty on certain facts and questions as stated in the said special case, as agreed upon for the governments of the two provinces, which has been transmitted by the Governor General of Canada and Council to your majesty's Secretary of State for the colonies in the words following. VIZ,
Mhm.
colon, I'm not going to read it.
Okay,
But if you go over on the next page, you see the decision of the Privy Council. And item number 1 is John Hamilton Gray has not become disqualified, because that was one of the arguments Quebec was making.
yes,
And item number 4, they say that the arbitrator appointed by Quebec had not the right to resign. And the government of Quebec had not the right to accept his resignation and to revoke his appointment. They're
yes.
making a definitive statement about the validity of the award. Would you agree with that?
Yes,
And let's just finish it off. And at item number 5, the Privy Council says the remaining 2 could legally proceed to hear the case and make a final award.
yes,
And that's what they did according to the Privy Council.
yes, yes,
Thank you. And item number 6, that so far as regards any objection made to the award in the special case, the award of the 3rd of September 1870 is valid, save as affected by the Dominion Act therein set forth. Now, do you know what Dominion Act they're referring to?
I am not sure.
Okay. And you can see at the bottom of this document that this was then communicated to the governments of Canada and the provinces.
Yes. Now that Dominion Act, I think set forth in the award is the reference. By the award of the 3rd of September 1870 is valid, save as affected by the Dominion Act therein set forth. I think that is a reference to the British North America Act, but they're not specific about it.
Okay. Thank you. Now, we talked moments ago about Section 142 and whether the arbitrations of 1895 were Section 142 arbitrations, and you said, well, you know, the acts don't mention it.
Right.
And so at tab 38, tab 5, page 38 of the compendium, we actually have the 3 acts that you were just referring to.
All right.
First of all, you would confirm, if you could just confirm, just quickly look at them, that those look to be 3 identical acts, one by Quebec in 1890, one by Ontario in 1891, and a 3rd by Canada in 1891.
Right.
Thank you. And the heading of the act, and I'm looking at the Quebec version, and I don't think it matters which one we look to, but these acts define the scope of the arbitrations. Would you agree with that?
There were, in a very general way, I think they set out, they enable a process. I suppose I would put it that way.
Okay.
There are other further documents which set out the scope of the arbitration.
Well, we start out with the statute, and I appreciate your speaking as a historian, not as
Yes.
a lawyer, because sometimes lawyers might say that statutes are more important than agreements that the parties make under a statute. But that's going to be something for argument. But what this statute says is an act respecting the settlement by arbitration of accounts between the Dominion of Canada and the province of Ontario and Quebec, and between the 2 provinces. That's what the title is, correct?
Yes.
And the first main paragraph says in terms of what I call the scope. Whereas certain questions have arisen or may hereafter arise in the settlement of the accounts between the Dominion of Canada and the province of Ontario and Quebec, and between the two provinces. So that, to my understanding, is what the parties are going to be engaging in an arbitration about.
Yes,
All right. And I want to go for particular to item number 3. It says, the arbitrators shall not assume to decide any disputed constitutional questions, semicolon. But if any are raised, they will note and report them with their award, but without delaying their proceedings. Now, in lawyer talk, to me, that's telling me as a lawyer that the arbitrators didn't have what's called jurisdiction to decide disputed constitutional questions.
that's right. I think the parties wish to preserve their right to have those constitutional questions decided by another course.
Right.
Yeah.
And so we know from the history of this that the Supreme Court of Canada weighed in on constitutional issues,
Yes,
and so did the Privy Council in 1896, correct?
yes,
But insofar as these arbitrators in 1895 and following, they were not supposed to decide constitutional questions.
they were not going to be the final deciders of constitutional questions. I think that some of the accounts on which they were issuing awards were going to affect disputed constitutional questions. And in that case, they had to put a statement in their award that they were proceeding on a disputed question of law. It opens up the avenues of appeal, of course, to the Supreme Court and the Judicial Committee of the Privy Council.
I can go a little bit longer or I can stop now. I probably have about another 45 minutes. I would think 40 minutes of cross.
All right. And Mr. Gover or Mr. Bass?
Yeah, I would estimate in the range of 15 minutes for cross-examination.
So we have an hour.
Yeah.
Is this a good time or do you want to?
No,
ask
it's
one or two?
fine.
Okay. No? That's it. So we'll break now and come back. Should we come back at 2? 2?
Yeah, that's fine.
Yeah, I hope. Right.
All
Did it.
right. We'll recess until 2 p.m.